They weren't looking for her. That's the part most people miss. This case didn't begin with a tip, a witness, or a report. It began with a routine traffic stop, one officers had made dozens of times before. A registered offender. A failure to update an address. A violation so common it barely raised an eyebrow. When police searched the car, they expected drugs. They expected excuses. They expected the familiar. What they didn't expect was that someone else's life was about to be pulled into the open through a phone that wasn't even hers. Inside that device were thousands of files investigators had already braced themselves to see. And then, something different appeared. A woman they recognized. Not a suspect. Not a target. Not someone anyone had been searching for. Yet, by the time detectives finished reviewing the contents of that phone, an entirely new case had been born. One that would leave officers, attorneys, and the public arguing the same question. Was this evidence of choice, or evidence of control? And once a confession is recorded, can the truth ever be rewritten? The phone wasn't unlocked right away. It never is. Before investigators can see anything, there's paperwork, warrants, signatures, approvals. Hours turn into days. Days turn into waiting. And during that waiting, detectives already believe they know what they're going to find. They've done this before. When a device belongs to a repeat offender, expectations are grim but familiar. Investigators brace for volume, not surprise. They expect the same patterns, the same crimes, the same faces. This phone didn't follow that script. When forensic analysts finally gained access, the scale was overwhelming. Tens of thousands of files. Images and videos cataloged across multiple apps. Some encrypted, some disguised, some hidden in plain sight. At first, it looked exactly like what they feared. Then something shifted. Mixed among the files were videos that didn't fit the existing investigation. Different setting, different camera angles, different person. A woman, not a minor, not anonymous, not hidden behind filters or masks. Clear enough that detectives stopped scrolling. They recognized her. That moment matters more than anything that followed. Because recognition changes how an investigation moves. It turns passive review into active pursuit. Suddenly, this isn't just about cataloging evidence, it's about identifying someone who lives somewhere, who has a name, who can be found. Analysts began isolating those files. They pulled metadata. They logged timestamps. They extracted GPS coordinates embedded deep inside the videos. The locations weren't vague. An apartment, a motel, addresses that existed in the real world. This wasn't something uploaded once and forgotten. The files stretched across months. Repetition. Consistency. A timeline that refused to be dismissed as a single moment taken out of context. That's when detectives ask the question they always ask when a case turns unexpectedly personal. Who is she, and how did she end up here? Background checks followed. Residency. Known associates. And then the connection appeared. She wasn't a stranger to the man whose phone started all of this. She knew him. Not casually. Not briefly. Their lives had crossed before, on again, off again, enough times that investigators began to wonder whether this case was about individual choices, or about influence, control, something darker. By the end of that first full review, detectives understood one thing clearly. This was no longer a side discovery. This was its own case now. And the next step wasn't about files or devices anymore. It was about a conversation that could change everything. One that would be recorded, documented, and replayed over and over again. Because once words are spoken on tape, they don't disappear. They wait. Welcome to Coziness Stories. If you enjoy calm, immersive stories like this, take a moment to subscribe and make yourself at home. The room was small. Neutral walls. A table bolted to the floor. 2 chairs, one for the detective, one for the person whose life was about to split into before and after. This wasn't a dramatic arrest scene. No flashing lights. No crowd. Just a knock. A request to talk. And a door that closed quietly behind her. From the start, investigators did what they always do in cases like this. They slowed everything down. They confirmed her name, her age, her address. They read her rights, clearly, carefully, making sure there would be no question later about whether she understood them. She said she did. The recorder clicked on. That sound alone has ended more cases than handcuffs ever could. Detectives would later say her demeanor surprised them. She wasn't hysterical. She wasn't combative. She wasn't silent. She answered questions. At first, they stayed general: relationships, timelines, how she knew the man whose phone sparked the investigation. She acknowledged knowing him. Described their relationship as unstable. On again, off again. Then the questions narrowed. Specific dates, specific locations, specific files. The moment investigators referenced the digital evidence, the room changed. Not dramatically, subtly. A pause that lasted just a beat too long. Eyes dropping to the table. A breath drawn deeper than before. Detectives asked a simple question. Do you recognize yourself in these recordings? According to court documents, she said yes. What happened next would become the backbone of the prosecution. Investigators alleged that during this recorded, Mirandized interview, she admitted involvement. Not once, not vaguely, but directly, acknowledging that she appeared in the material, that it was recorded, and that it was shared. Those admissions didn't come wrapped in emotion. They came matter-of-fact. And that's often what makes them powerful in court. Confessions don't have to be dramatic to be damaging. They just have to be clear. By the end of the interview, detectives believed they had what they needed. Digital evidence, corroborating data, and statements that aligned with what they had already seen. She was released pending further court proceedings, but the case was no longer theoretical. It was active. It was public. And it was about to get louder. But interviews don't exist in a vacuum. What isn't said can matter just as much as what is. Because after that recording ended, after she walked out of that room, another story began to form. One that wouldn't appear in affidavits at first. One that wouldn't be introduced by detectives. It would come from her, publicly. And it would challenge everything investigators believed they had locked down. It didn't come from a courtroom. It didn't come through an attorney. It came online. While investigators were still organizing files and prosecutors were reviewing charges, a second narrative appeared, one the state hadn't anticipated. And it spread fast. From jail calls to social media posts, the message was the same. She said she was forced. Not pressured. Not influenced. Forced. According to her claims, the man whose phone started the investigation wasn't just an acquaintance or a bad partner. He was violent, controlling, and dangerous. She alleged abuse, coercion, fear. She said the acts seen on video weren't consented to, but recorded under threat. And suddenly, the case wasn't just about evidence anymore. It was about power. The internet split instantly. Some people believed her, pointing to the history of abuse in similar cases, the dynamics of coercive control, the reality that victims don't always act how we expect them to. Others were brutal in their rejection. They questioned why she didn't report earlier, why the video spanned months, why there were no visible signs of resistance. They pointed back to the interview, the words on tape, the admissions, and they asked the question prosecutors would later face head-on. If this was coercion, where is the proof? For investigators, the defense changed nothing and everything at the same time. Nothing, because the charges were based on digital evidence and sworn statements. Everything, because juries don't just weigh facts. They weigh stories. And now there were two. One told through files, timestamps, and confessions. The other told through allegations of fear, violence, and survival. Neither could be ignored. Detectives quietly began reviewing what hadn't mattered before. Prior police reports, medical records, messages between the two, any documentation of domestic violence. Because if coercion could be proven, it wouldn't erase the case, but it would reshape it. And if it couldn't, then the defense would collapse under its own weight. The justice system doesn't move at the speed of outrage. It moves at the speed of verification. And that meant the next phase wouldn't be emotional. It would be forensic. If this story is drawing you in, subscribing to Coziness Stories helps you enjoy more tales like this, every time you return. Next came the recorded statement. Every second of it was reviewed again, tone, pacing, wording. Prosecutors focused on what was said before any public defense appeared. No mention of threats. No reference to violence. No claim of being forced. Silence in legal terms can be loud. The state didn't argue that victims always disclose abuse immediately. They argued something narrower. This interview matters because it captures her words before strategy existed. But the defense wasn't backing down. They argued that coercion doesn't always look dramatic. That victims comply to survive. That fear doesn't turn off just because a recorder is running. They pointed to the power imbalance. They pointed to his criminal history. They pointed to the reality that many victims protect their abusers, until they don't. And suddenly, the case wasn't about proving something happened. It was about proving why it happened. If this ever reached a jury, they wouldn't be asked to judge morality. They'd be asked to judge credibility. Does the digital evidence support free will, or prolonged control? Do admissions outweigh later explanations? Can coercion exist without documentation? These aren't questions with comfortable answers. They're the kind that keep jurors awake. By the end of this phase, prosecutors believed they had enough to move forward. The defense believed they had enough to create doubt. And the woman at the center of it all was no longer just a subject of investigation. She was a defendant. Charges don't arrive with drama. They arrive on paper. Type, stamp, filed. And once they exist, everything changes. The charging documents were direct. 2 felony counts. Same statute. Same classification. Each count tied to specific files, specific dates, specific acts alleged to have occurred in Indiana. Not rumors, not speculation. Formal accusations. From that moment on, the story stopped being an investigation and became a case. She stood before a judge who had already read everything. The affidavit, the summaries, the admissions. This wasn't a trial. It wasn't even an argument. It was procedural. The judge confirmed identity, outlined the charges, and explained what came next. A public defender was appointed. Conditions were set. She wouldn't be held behind bars, for now, but her freedom came with rules. Monitoring, restrictions, no contact clauses. The court wasn't deciding guilt. It was deciding risk. Within hours, the case docket was public. Names spread. Screenshots circulated. Commentary exploded. This wasn't just a legal process anymore, it was a spectacle. Some demanded harsh punishment. Some demanded patience. Others demanded answers the system couldn't give yet. And through it all, the clock started ticking. Because once charges are filed, the law doesn't rush, but it doesn't stop either. While the public argued, attorneys worked quietly. The prosecution began preparing exhibits, files, transcripts, expert testimony. The defense began building context, relationship history, mental health angles, claims of abuse. Each side understood the same truth. This case wouldn't hinge on shock value. It would hinge on interpretation. No verdict yet. No resolution. Just waiting. For motions. For hearings. For the moment when evidence would be tested instead of summarized. And for the woman at the center of it all, this waiting may have been the hardest part. Because uncertainty doesn't fade, it stretches. Courtrooms have a rhythm. Not loud. Not fast. Measured. This is where stories slow down and details take over. Before a jury ever hears a word, attorneys argue in silence-heavy rooms about what can be heard at all. The prosecution moved first. They sought to admit digital files recovered through forensic analysis, metadata tying files to dates and locations, the recorded interview and alleged admissions. Their argument was simple. The evidence was lawfully obtained, properly preserved, and central to the case. The defense pushed back. They challenged relevance. They questioned context. They argued prejudice. Not because the material didn't exist, but because how it was presented could determine whether a jury judged facts or reacted emotionally. The judge listened. Judges always do. Next came the experts. Digital forensic specialists explained, step by step, how files are recovered, authenticated, and traced. How timestamps work. How GPS data is embedded. How sharing pathways are reconstructed. No opinions. No drama. Just process. The defense cross-examined carefully, probing margins of error, alternative explanations, the limits of technology. They didn't need to disprove the evidence. They needed to soften it. Then came the issue no motion could avoid. Coercion. The defense signaled its intent to introduce evidence of alleged abuse. Messages, statements, patterns of control. The prosecution objected. They argued relevance again. Not because abuse claims never matter, but because claims must connect directly to the charged acts. The judge's ruling would shape everything. Allow too much, and the trial becomes a referendum on a relationship. Allow too little, and the defense loses its backbone. The ruling was measured. Some evidence allowed. Some restricted. Nothing sweeping. Balance. This stage decides what the public never sees. What jurors will be allowed to know. What will remain sealed. What questions can be asked, and which must stay unspoken. By the end of these hearings, the case was slimmer, sharper, and far more dangerous for both sides. Because now, there would be no hiding behind paperwork. Only testimony. Trials aren't won in the courtroom. They're won before anyone ever takes the stand. By the time this case edged closer to trial, both sides knew something uncomfortable. This wasn't about shocking evidence anymore. It was about who the jury would believe. The state didn't plan to overwhelm. They planned to simplify. Their strategy was built around 3 pillars. Consistency. The digital evidence didn't contradict itself. Timing, admissions made before any public defense emerged. Control, a narrow case that avoided unnecessary emotion. They would not speculate about motives. They would not psychoanalyze. They would repeat one message again and again. This case is about what was done and what was admitted. Nothing more. Nothing less. The defense knew the evidence was heavy, so they didn't try to erase it. They tried to reframe it. Their strategy was human, not technical. They wanted jurors to see a woman shaped by fear, trapped in a dynamic she couldn't escape. To understand that survival doesn't always look rational. That compliance can be mistaken for consent. Their unspoken goal wasn't to prove innocence. It was to introduce reasonable doubt through empathy. If jurors questioned why someone might comply, even once, even silently, the defense believed doubt would follow. This is the part the public rarely sees. Every word in opening statements is debated. Every phrase is tested for emotional weight. Should the prosecution say, confessed? Or admitted? Should the defense say abuse? Or coercive control? Language shapes reality inside a courtroom. And both sides knew it. Throughout this preparation, one decision loomed larger than all the rest. Would she testify? If she did, the jury would hear her voice directly. If she didn't, the jury would hear only interpretations of her words. Either choice carried risk. Because once someone takes the stand, they don't just tell a story. They surrender control of it. By the end of this phase, everything was locked in. Exhibits marked. Witness lists finalized. Strategies sealed. All that remained was the moment when 12 strangers would hear it all and decide what it meant. You're listening to Coziness Stories. Subscribe now so you don't miss the next story waiting for you. They filed in quietly. No one spoke. 12 people who had never met, now bound together by a single responsibility: decide what was true. Before evidence, before testimony, before the story itself, there were questions. About bias, about beliefs, about whether they could sit through disturbing material and still think clearly. Some were excused immediately. Others hesitated, but stayed. In cases like this, the jury is the most fragile element. One reaction too strong. One assumption too fixed. Both sides watched closely. Because juries don't just listen, they feel. The prosecution went first. They spoke calmly, deliberately. They told jurors this case would be uncomfortable, but not complicated. Digital evidence. Clear timelines. Admissions captured on tape. They asked jurors to focus on what could be proven, not what could be imagined. You don't have to like this evidence, the prosecutor said. You just have to decide whether it's true. The defense followed, and the temperature changed. They spoke of fear, of control, of how abuse doesn't always leave bruises, but it leaves silence. They told jurors this was a case about power imbalance, not intent. Ask yourself, they said, what survival looks like when every option feels dangerous. Screens lit up, not with images, but with data. File names, dates, locations. The prosecution was careful. They didn't sensationalize. They didn't linger. They let the existence of the file speak. Experts testified. They explained how metadata works, how devices log activity automatically, how manipulation is rare and detectable. The jury took notes, slowly, carefully. Cross-examination didn't challenge the files. It challenged assumptions. Could someone be recorded without agency? Could fear last months? Could compliance be a survival strategy? They didn't deny the evidence. They reframed it. By the end of the first days of testimony, one thing was clear. This case wouldn't hinge on shock. It would hinge on interpretation. And the jury, 12 strangers, was already being asked to do something harder than judging facts. They were being asked to judge human behavior under pressure. By the time the trial reached its final stretch, the courtroom felt heavier. Not louder. Not more dramatic. Heavier. Because now the jury wasn't just listening. They were deciding. After days of testimony, exhibits, and carefully chosen words, the judge gave the jury their final instructions. No opinions. No guidance on what to feel. Just the law. They were reminded of the standard that defines every criminal case in America. Beyond a reasonable doubt. Not beyond discomfort. Not beyond suspicion. Not beyond outrage. Doubt. As the jurors stood and filed out to deliberate, one question followed each of them into that private room. If something appears clear, but the explanation is not, what do you do with that uncertainty? Because this case offered no clean moral lines. The evidence existed. The admissions existed. The allegations of coercion existed. And the law demanded they weigh all of it, without guessing, without assuming, without filling gaps with emotion. No cameras. No microphones. Just 12 people, a table, and stacks of notes. Some jurors focused on timelines. Others focused on psychology. Some returned again and again to the interview, what was said and what wasn't. They asked each other the same questions prosecutors and defense attorneys had circled for months. Can fear explain consistency? Does a confession outweigh a later claim? Where does accountability begin when control is alleged? There were no easy answers. Only discussion. While the jury deliberated, the world waited. Headlines paused mid-sentence. Comment sections filled with predictions. Opinions hardened. But none of that entered the jury room. Because justice doesn't happen online. It happens in silence. Whatever verdict came next would do more than decide guilt or innocence. Would define how coercion is understood. How digital evidence is trusted. How society judges survival versus responsibility. And it would stay with the jurors long after the case number faded from memory. Because some questions don't end when a verdict is read. They follow you home. The knock came softly. 3 taps on the jury room door. That sound, more than any gavel, more than any verdict form, is what ends the waiting. Jurors filed back into the courtroom one by one. Faces unreadable. And still. Everyone stood as the judge returned to the bench. This was the moment every true crime story builds toward, but rarely captures honestly. Because the truth is, verdicts don't feel cinematic. They feel final. The defendant stood. Her attorney leaned in, whispering something last minute. Words meant more for grounding than strategy. Across the aisle, the prosecution watched without expression. No smiles. No tension release. They knew the same thing the judge knew. Once the verdict is read, nothing can be taken back. The judge nodded to the jury foreperson. A single sheet of paper was unfolded. Hands shook, not dramatically but enough to be noticed. That too matters. Because jurors don't shake when they don't care. There's always a second, just one, before the verdict is read. In that second, everyone imagines a different ending. Guilty. Not guilty. Hung jury. Careers, families, futures. Split into separate timelines by a single sentence. The foreperson began to read. And no matter what was said next, conviction, acquittal, or deadlock, one truth remained unavoidable. This case would never be resolved in the way people wanted. Because even a verdict doesn't explain everything. It only decides what the law can prove. As soon as the words were spoken, some people exhaled. Some people stiffened. Some people stared straight ahead, unable to react at all. Outside the courtroom, phones buzzed. Headlines updated. Public opinion snapped back into motion. But inside the room, something quieter happened. A shared understanding. That everyone involved, jurors, attorneys, families, would carry this case with them long after the court moved on. They don't heal trauma. They don't undo harm. They don't make disturbing facts easier to live with. They simply answer one narrow question. Did the state meet its burden? Nothing more. Nothing less. With the verdict delivered, one chapter closed. But another opened immediately. Appeals, sentencing, public fallout, and the long shadow that cases like this cast. Because some stories don't end when the courtroom empties. They echo. Long after the verdict is read, one question lingers. What did this case actually change? When the courtroom emptied, the case didn't disappear. Scattered. Into records. Into memory. Into the quiet places where people try to make sense of what they've witnessed. Because verdicts end trials, but they don't end conversations. In the weeks that followed, coverage shifted from what happened to what it meant. Legal analysts debated digital evidence. Advocates argued about coercion and accountability. Others focused on the system that allowed multiple crimes to intersect before intervention occurred. And beneath all of it was an uncomfortable truth. This case wasn't just about one person. It was about how modern crimes are uncovered, how evidence lives online, and how power dynamics complicate justice. The justice system answered the question it was designed to answer. Did the evidence meet the legal standard? But it could not answer the questions people kept asking afterward. How does coercion really present itself? When does survival blur into culpability? How many crimes go unseen because they're buried inside other crimes? Those questions don't belong to a verdict. They belong to society. Cases like this change procedure quietly. Investigators become more attentive to crossover crimes. Prosecutors become more cautious with digital confessions. Defense strategies evolve around trauma-informed arguments. No press release announces these shifts. They happen anyway. True crime often promises clarity. This case offered none. It offered a reminder instead that real life doesn't resolve neatly, that evidence can be strong and stories can still conflict, that discomfort doesn't mean uncertainty, and certainty doesn't mean peace. If you're left unsettled, that's not an accident. The most disturbing cases aren't the ones with shocking details. They're the ones that force us to confront how fragile understanding really is. And that's why this story matters, not because it's extreme but because it's real. Some cases don't ask for judgment. They ask for awareness. Thank you for spending this moment with Coziness Stories. Subscribe, rest easy, and I'll see you in the next story.